An important property rights case made its way to the North Carolina Court of Appeals this morning. In a pair of lawsuits called Town of Apex v. Rubin, a property owner wants the Wake County town to remove a sewer line illegally installed on her property. John Guze, John Locke Foundation Senior Fellow in Legal Studies, has been following this case closely, and he joins us now with reaction to the hearing. John, this boils down to basically a property owner who says, Apex, you installed this sewer line illegally, move the sewer line. But there's more to it than that, and it interests you. You actually wrote a brief in support of this case. Why is this case of such interest to you?
Well, for several reasons, but the most important one is simply this. At the basis, what happened in this case is the town of Apex, they filed a petition for condemnation over this property to build a sewer line. It went to the Superior Court in Wake County, and the judge said, this is not for a public purpose. This is for a private purpose. Therefore, it's unconstitutional. And that decision, that judgment was appealed first to the North Carolina Court of Appeals and eventually to the North Carolina Supreme Court. It was upheld at both of those levels. So it's a final judgment. It's on the record and it's incontestable that this is not a public purpose taking. It's for a private purpose. Our Constitution and the US Constitution forbid that. So we feel it's very important that however this plays out, we need to vindicate that principle. We don't want towns and cities or any governments to be able to take property for a private purpose, only if it's a public purpose. That's one thing that's interesting about it. Shall I go on? Another aspect of it that interests me is that the reason this got so complicated is because of something called a quick take statute. Under North Carolina law, most of the time, if a municipality or a county wants to take property, they have to go through a normal condemnation proceeding where they give the property owner notice. There'll be a hearing. The property owner will have an opportunity to contest it, making arguments, for example, that it's not for a public purpose. And all of that will be resolved before the condemner proceeds to do anything with the property. But under the quick take statute, the Department of Transportation and some municipalities, not all, but Apex is one of them, are allowed to simply go ahead and start building whatever it is they want to build on the property they've asked to have condemned. And then the question is, what happens if at the end of the day, the courts deny their petition, as happened in this case, and say it's not for a public purpose? And I think this throws the whole quick take statute into some question. And I think we have to reconsider whether, in the first place, we even want to have this power. And in the second place, whether we want to extend it to municipalities. And if we do, we have to figure out a way to ensure that nothing like this ever happens again. Because what happened was Apex went ahead and built a sewer before the Superior Court handed down its decision and found that, no, it wasn't for a public purpose. That's why we're in this difficult situation now.
So right now, the sewer line is there. It serves about 50 homes. And so if there was a ruling in favor of the property owner, Apex would have to find some way to serve those 50 homes. You had a chance to monitor what was going on with the online court presentation before a 3-judge panel of the Court of Appeals. What did you think about how the judges responded to the arguments from both the property owner and the town?
Well, it's clear that they're conflicted, and you can't blame them. They're in a very tough position here. On the one hand, none of them likes the idea that a city can get away or a town can get away with something like this. You should not be able to install and maintain a sewer line that was, if a court has said it's for a private purpose, because that makes it unconstitutional. Citizens have a right to have their constitutional rights upheld. On the other hand, though, the equities here are very difficult because subsequent to that decision by the Superior Court saying this was not for a public purpose, the subdivision that this was intended for was developed and all these homes got hooked up. And now we have this awkward situation where 50 homeowners are depending on that sewer. Any kind of alternative solution, if they reroute it, they build a pumping station, all the alternatives are expensive. They're going to take time, and it's going to be a lot of inconvenience involved. So it's difficult. It's a hard call for the court, I think.
I want to hone in on one judge who had a couple of contrasting reactions. Judge Chris Dillon, in talking to the lawyer for the town of Apex, basically said, are you telling me that court precedents are saying that if government comes on to my property, put something on there illegally, that the only thing I could do about it is end up getting some payment, some just compensation? So he seemed to be in favor of the plaintiff in this case, Rubin. But on the other hand, in talking to the lawyer for the Ms. Rubin, he said, where is there anything in our court procedure, history, precedent that says a court can order a town to go back and take a sewer pipe out? So he seemed to be, as you mentioned, particularly conflicted about what to do about all of this.
Well, that's true. And the town's attorney, Mr. Farrell, it's important to notice his answer to that first question was, that's right. Under North Carolina, as the town of Apex is interpreting the law, municipalities can definitely do this. They can go ahead and build a sewer line across your property, even if a court has said it's illegal and violates the Constitution. And all you can get in the way of a remedy is just compensation. You cannot force them off of your land, even though there was an unconstitutional taking. That's what they say the law is. The Beverly Rubin's attorney was saying that can't be the law. And there were a number of reasons for it. And one of the sort of ultimate reason is a case called Quorum, which the Supreme Court said, look, constitutional rights are basic. You don't have to propose any particular remedy. The courts just have to enforce them. But again, it's a tough one to figure out exactly how to do that in this case. Whether they can issue an injunction, there's no precedent for it because nothing like this has ever really happened before. And I have to say, part of the reason we're in this position is that whoever was representing Beverly Rubin at the outset should have gone ahead and requested an injunction right at the time they got, as part of their request for relief at the beginning. If they'd have done that, we wouldn't be here. And I'm sure that going forward, no property lawyer is going to let that happen again. But it's a new situation. It'll just be interesting to see how the court figures it out.
Often when we talk about legal cases and their ultimate resolution, you can point to a particular outcome that's going to be the best and the proper legal outcome. It sounds as if in this case, it's really hard to come up with what that outcome would be. If Beverly Rubin wins, what she's asking for is for Apex ultimately to move this sewer line, not necessarily right away, but at some point within a reasonable amount of time. It's hard to imagine that Apex is going to end up having to move the sewer line that already serves 50 homes. Are we in a position where we really have to struggle to find what the best outcome will be in this case?
Well, yes, I've been scratching my head about it for several months now, and I haven't come up with a good solution that the court could apply. But my feeling is that somehow or other, it's important to vindicate the principle that under our Constitution and under the US Constitution, governments can only take property for a public use. So they have to come up with a solution that leaves that important principle in place and doesn't weaken it. It's also important, I think, to see to it that the town of Apex is punished. I mean, when you exercise the quick take process, it's at your own risk. That's clear. The courts have already made that clear. And sometimes you lose. If you take a risk, it doesn't always go your way. So, and instead of accepting that they lost, Apex has continued to fight this and find these procedural ways around and try to say that nevertheless, we get to keep our sewer. So it's important for Apex to be punished so that, again, municipalities and counties don't try to do this again. But it would be awfully nice if there was a way to solve it without having to cause all the expense and inconvenience of rerouting that sewer line. I just haven't been able to figure out what that is.
Well, the hearing took place today. It is not clear when the three-judge panel will issue its ruling, but when it does, we know that one person who will be poring over the documents to learn what they say about where the law stands in North Carolina is John Guze. He is Senior Fellow in Legal Studies for the John Locke Foundation. John, thanks so much.
Thank you, Mitch.